My name is Tamiska Secrease-Williams, and I am a juror in our Week 2 discussion of our courtroom drama for case number 3. This case involves the disclosure of patient health information. I have reviewed the videos of both the defendant and the plaintiff in this case. First, in my review of the defendant's video as presented by Marlene, Marlene is a representative of AU Hospital. She is a manager in the medical records department of that entity. Marlene has testified that they received a subpoenaed request for medical records for patient Jennifer. In her video testimony, Marlene presented evidence of the privacy disclosure statement that is given to all of the patients who are seen or treated at their hospital. She indicated that all patients are given a copy of the statement that they also sign. And in this statement, it indicates what the patient's rights are related to their patient health information, how it's disclosed, when it's disclosed, to whom it's disclosed. The patients have a right to identify how they want to be communicated about their information. The patient, in this disclosure statement, it also gives the patient a right to add in any restrictions related to who they can share information with or what information they choose not to be shared. However, the statement also gives the hospital the right not to honor those addended requests by the patient, although they're noted within the form. So this evidence provided or submitted by the defendant basically communicates or identifies the rights of both the patient and the facility related to the sharing of this personal health information. An interesting statement that I noted within the video provided by Marlene is that she stated that she testified that there was a failure on the part of the hospital to determine that reasonable efforts were made to contact the patient and to notify them of the request. So she testified that she did not ensure that the plaintiff was reasonably contacted by the third party to get the information, or reasonably contacted the patient themselves to notify them of the request. I also reviewed the video of the plaintiff, which was provided by Kevin, who was acting as a representative for the patient Jennifer. Kevin also provided some information related to laws that protect patient health information and when that information should be disclosed, and the requirements for notifying and contacting the patient prior to releasing their information to an entity based on a subpoena request that is not supported by a court order. What I also found is that each of the parties, the defendant and the plaintiff, both communicated pretty much the same information in their understanding of what the law was related to PHI information requested via subpoena. And I have also researched and found the following information that states that a HIPAA covered provider or plan may disclose information to a third party issuing a subpoena only if the notification requirements of the privacy rule are met. So it is not illegal or unethical to respond to these requests. However, the caveat to that is that the privacy rules for notification requirements are met. The provider or plan should receive evidence that there were reasonable efforts to notify the person who is the subject of the information about the request, so that the person has a chance to object to the disclosure or seek a qualified protective order for the information from the court. And because the defendant testified in her own video that the hospital did not meet the privacy rule notification requirement for responding to a subpoena request for patient health information, I rule in favor of the plaintiff. Thank you.